Good afternoon, welcome, and thank you very much, everybody, for joining us in this powerful educational Lunch and Learn, which is brought to you by Family Partners of Morris and Sussex counties. Right here, this is your host, Patricia Houston, and today is joining us Donna Brown, who is a registered representative and investment advisor representative of Equity Services. Welcome, Donna.
Good afternoon. First, thank you for everybody for joining us. Our organization is called Special Needs Funding Coach. We do three things for families with special needs dependents. Number one, we make sure that that person always qualifies for government support services. We're going to talk a lot about that today in our presentation. Number two is to help families answer the question, okay, what happens when I'm gone? And number three is to maximize your resources wherever you are, either on the age spectrum or economically, so you can try to get the things accomplished that you want in special needs planning. So I'm with Elizabeth today. Elizabeth is our client relationship manager. When we do a presentation, particularly since you're sharing time with us, and today it's possibly during your lunch hour, we want to do three things that we have objective-wise. Number one, we obviously want to educate you. You came here to learn. We want to deliver on that. Number two, we want you to have at least one actionable item where when you walk away from this workshop, you can say, I'm glad I was there, and you can go do something today to improve your planning. And then three, we like our programs to be interactive. So when you have a question, please type it in the chat. Elizabeth will stop me periodically so we can answer the questions as we go. And then at the end, if you still have questions, we'll stay as long as you want. Lastly, and most important, we're going to put a survey in the chat. We're asking everyone who's on our workshop today to complete that survey for us. Let us know what specific information you want. If you'd like a consultation, if you provide us with a mailing address, we'll send you a whole Special Needs Funding Coach resource folder with important information in it. So with that said, and out of respect to everybody's time, we're going to get started, but please do not hesitate to type questions as we go. So the whole workshop's revolved around answering this question: what is important to you as a caregiver? We recognize that when you have a loved one with special needs and you're caring for them on a day-to-day basis, you do things out of habit, you do things out of necessity, you do things in a category that we always call unconsciously competent. You do things that you need to do for your loved one. So we also recognize that that question is going to come up, and it may be the thing that keeps you up at night is, okay, who's going to step into my role? What happens when I'm gone? So over the next 40 minutes or so, we're going to go through 10 steps, a step-by-step process to help a family recognize some of the things that they may want to do, some of the things they may not have addressed yet, or some things that may need to be revisited. So step one says plan for the future. May sound obvious, but we all recognize that having a specific plan for your loved one with special needs, number one's not easy. Number two, there's no main template where everybody can do one and it's easy to get done. And number three, many times families just don't either have the time or the ability to have a planned and coordinated plan for their child or their loved one with special needs. So today, what we're going to talk about is if we're making that plan, what are some of the most important things we want to make sure we include and that are prepared for in that plan? The first bullet point you see there says medical treatments. We recognize in the special needs world, medical treatment is a very broad term. It may be social supports, it may be mental services, it may be all of those things that allow your loved one with special needs to continue to go on with their day-to-day lives. But the more you plan for that in advance, the more things that you know about benefits and how to supplement them, better your plan will be. Second area is education. We recognize that in the school system, your child with special needs or your loved one with special needs gets to stay in the school system until the age of 21. But when the age of 21 happens and that school year ends, then all of the services that were now being provided by the Board of Education's budget now change, and the delivery system for adult services with special needs the delivery system changes, to Medicaid. So when we're talking about that stuff, we want to plan for that. And then the last one is housing. As we go through this workshop, what we'd like you to do is sit back and think and envision about your loved one's future. Where are they going to live as an adult? Are they going to live independently? Are they going to need supports? Are they going to live at home with you? Are they going to live with other family members? Are they going to live in a group home type setting? All of these things, particularly now, there are many advances in those areas that are happening, and being prepared for those things is going to help you have the most success for your loved one. The idea is pretty simple. It's peace of mind and quality of life. So we mentioned about at age 21, the delivery system for adult services with special needs changes to Medicaid. So here's the first question that we're going to ask. And if you know the answer, we'd like you to type it into the chat. And we're going to try to have some fun and give away some cash and prizes. So here's the question. What is the maximum amount of assets that an individual can have in their name and still qualify for Medicaid benefits? What's the maximum amount of assets an individual can have in their name and still be Medicaid eligible?
Any guesses? You can just type it in the chat.
Type it in the chat.
Yeah.
Take a guess. It could be worth some money to you.
Okay, we have one guess of 10,000. Any other guesses?
Okay. So who said 10,000? Lisa, what we're going to do is, since you participated and we're happy you tried, we're going to send you a scratch off, and you could possibly win up to $2,000 quickly. So maybe it's worth some money to you. But number one, we do want to have some fun, and we want to give away some cash and prizes, but we don't want you to lose sight of the irony here. We don't want you to leave your planning for your loved one to chance. But with that said, the $2,000 is the magic number. An individual can only have $2,000 of assets in their name to be able to qualify for Medicaid-related services. Now, most people think first, when you hear the word Medicaid, that it's health insurance for individuals that can't obtain it anywhere else. It's a government support services. The reality is, the entire delivery system for special needs services for adults with special needs is also delivered through Medicaid. So we want to make sure that we position assets that they're not in our loved one with special needs name when they turn age 21. So it's the first challenge, it's the first hurdle, it's the first catch-22, as we describe it, of special needs planning. How are we going to have our loved one get the level of independence that we want them to achieve? How are we going to get them to have the best quality of life that they can have, but they need the Medicaid-related supports to achieve it and can't have assets in their name? So it becomes the first pillar of our special needs planning. We talk about things like an ABLE account, which is a savings account for people with disabilities that does not count against Medicaid assets. We have a whole workshop on that. We'll work with Patricia and schedule one for the future. But for today, we want everybody to recognize that $2,000 limit. And what you see on the top of the screen is a little reminder where it says review beneficiaries. Most everyone on our workshop either has group life insurance at work, a retirement plan, or individual life insurance. And all of those contracts, you write out who a beneficiary is. Most people recognize that. However, at Special Needs Funding Coach and in our decades in the industry, we do quite a few group benefits, and we recognize that there's something called a contingent beneficiary. if a contingent beneficiary is the person who receives the money, if the primary beneficiary passed away, either in a common accident with the insured or the insured never changed that beneficiary, then the law states those monies go automatically divided evenly amongst your children. So this is a mistake that happens all too often. Think about this story for a minute. You have somebody who doesn't recognize or know this. They have their loved one with special needs become a beneficiary of a retirement plan or a life insurance benefit. And now the assets in that person's name are immediately over $2,000. Think about your loved one with special needs as an adult. They're happily functioning either in a job, in a day program, some types of community supports. Now they lose a parent and they're immediately removed from their Medicaid-related services because they have too much assets in their name. It is the easiest thing to avoid, and it is the first takeaway that we want you to write down today from the workshop. And we want you to call your insurance companies, call your retirement plans, ask them for a change of beneficiary form. You may list the primary beneficiary exactly the way you have it now, if it's not your loved one with special needs. But for a contingent beneficiary, it needs to be someone or some entity that is not your loved one with special needs, whether it's another relative or whether it's a trust, which we're going to talk about later on in the workshop. But for today, your first takeaway and your action item is to make sure you get your beneficiaries updated. Everybody got that, right? Okay, so the other thing you see there are things like inheritances and assets that are other than cash. So the other item is if you have a family member who you believe may want to leave your loved one with special needs in their estate planning, because they think that would be a noble and loving gesture to do, you need to remind them that they cannot leave assets directly to that individual. Step 3 says have a family meeting. Now, what we want to get across here is we recognize that when we have a family, and that family includes a loved one or a sibling with special needs, then it's everyone's responsibility for day-to-day life to get things done and to support that individual the way everybody needs. What we also recognize is that when we're talking about what happens when that individual is an adult, when we're talking about what happens when I, the mom, dad, or guardian, are no longer here, who steps into that role? And this is where we want to remind families that this is not where you can sit back and wait for laws to change. This is not where you hope another sibling or family member is going to step up and take that role. We may intend that to happen, but if it's not discussed, there could be issues. Think about this for a minute. If you have a loved one with special needs, they have a sibling, and you want that sibling to step into your role. We have to think about 3 things when you say that. 1, are they geographically able? Are they going to be living in the same area you live in? 2, are they physically and emotionally able? Meaning, do they have family of their own where maybe they can't take on that responsibility or they're not financially able? And lastly, are you planning to make sure that if you ask that, you have a plan for that to take place successfully? So later on in our workshop, we're going to talk about a document we use at Special Needs Funding Coach that kind of makes that family meeting more professional in terms of results, and more importantly to you, to make it more comfortable to have that discussion. Step 4 says create a team. So what we want you to envision is your loved one with special needs. And we have a round table or a conference table. And at that table are people like ourselves that are financial professionals and special needs, people that are legal professionals, the health professionals you work with, the education professionals, and then the social services people that will step into your life when your loved one becomes an adult. Imagine that meeting's taking place and everyone has one common theme, and that is the quality of life and the level of independence for your loved one with special needs. Now, we know realistically that meeting doesn't physically happen, but we also know that you can be the person that helps coordinate all those things to make the results of that meeting happen. And again, we're going to help you do that when we work with families and provide you with resources to help you get that done. Step 5 says get additional resource support. We congratulate you for being on the workshop because you're already doing that, thanks to Patricia and the family services organizations. We also want to talk about government agencies. This is an important place where we want to talk about some chronological dates, ages, and things that happen. So we mentioned already about Medicaid. When our loved one with special needs turns age 21 and they age out of the school system, the primary delivery system for services for special needs adults is delivered through Medicaid. So we have to have our loved one with special needs Medicaid eligible. How does that happen? Number one, we already addressed the financial side, meaning they can't have more than $2,000 of assets in any account directly in their name. Secondly is Social Security. When your loved one is a minor, they don't qualify for Social Security support because that would be dependent on the level of resources of mom and dad. So typically most families don't qualify. However, when your loved one with special needs turns age 18, now their qualification for government support services is based on their own independent resources as an adult. What does that mean? That means at age 18, it's one of the first most important action items that a family needs to address and will have to address. So here's our next question if you want to try to type the answer into the chat. The question is, who can tell me the difference between SSDI and SSI? Who can tell me the difference between SSDI and SSI? And while you think and try to type, and there's no penalty for being wrong. I'm going to take a sip of my coffee. No guesses?
Wait. Yes, SSDI is for the disabled. Another said SSD is Social Security Disability.
Okay. Who's the first one that said disabled?
Paula.
Paula, can you unmute for a second? Recognize the irony. Do not leave this type of planning for your loved one to chance. But what you said was accurate in that SSDI is Social Security Disability. So if you and I have a long-term disability that by definition qualifies for Social Security disability support, we receive financial support based on our work history. SSI, as you see on the bottom of the screen, supplemental security income, is designed for those people to provide basic food and shelter support for those people that don't have a work history or may never be able to earn enough income to have enough work history to qualify for the other type of Social Security. Now, there are 3 things that are important to know about this. Number one, when your loved one is reaching the age of 18, 3 months beforehand, you should be applying for SSI. Number 2, even if you want your loved one to go to college and you want them to be independent, if they need supports now, apply for SSI. Lastly, is you need to be prepared. Social Security is providing this money for basic food and shelter. And in the state of New Jersey, the maximum amount is somewhere close to $900 per month. However, when you are applying for SSI, many families automatically say to Social Security, of course, my loved one is going to be living with me. And Social Security rewards you for that by reducing your benefits by up to 1/3. Because if you're providing food and shelter, then Social Security says, why do we need to give you money to do that? So you need to be prepared to tell Social Security that you're either A, charging your adult child or your adult with special needs rent, and you would have to record that rent as income, or B, you have to have a list of household expenses and then divided by the number of people that are in the house. And those are the expenses that your loved one with special needs is going to be responsible for. They're part of the cable bill. They're part of the utility bill. They're part of the food bill. You need to be prepared with this, because if you have a reduction in benefits of a third, that's a couple $100 a month that you could be using for long-range planning for your loved one with special needs. Everybody got it? At the age of 18, you apply for supplemental security income, SSI. Now, second piece, we talked about Medicaid benefits and qualifications. We already know you can't have $2,000 of assets. The other thing is, when your loved one turns age 21, if they're receiving even $1 of SSI, they automatically qualify for Medicaid. So those are the two most important things to be aware of. And in chronological order, SSI at age 18, and then Medicaid age 21. Anyone have questions that you'd like to address before we move on?
There's none in the chat. If somebody has a longer question and they want to unmute to speak it, I think Patricia can pause the recording, so just let us know if you need to do that. Otherwise, I'll keep watching the chat.
There you go. Okay, so step 7 now, we're going to talk about the legal side a little bit. Now, here's our disclaimer. At Special Needs Funding Coach, we're chartered special needs consultants, chartered financial consultants. We are not attorneys. We do not do the legal work. But when we talk about the importance of the 3 most important things in special needs planning, the legal side is one of them. So over the next 5 to 10 minutes, what we want to do is talk about estate planning in such a direct and simple manner that you never forget it, number 1. And number 2, no one can ever confuse you about it. We recognize that there are legal professionals in the special needs community that give workshops, and we appreciate that, and we like that commitment, and we work with many of them. But we also recognize sometimes the terminology they use isn't easily graspable or understandable. So let's talk about first a will. Everyone knows they should have a will. Families that we work with, however, 70% don't have one. Why? Well, never got around to it, or when our children were younger, we couldn't decide who would be guardian, so we just never addressed the issue. Well, everyone needs to have a will, and when you have a loved one with special needs, it is imperative to have a will. So let's talk about what a will is, and let's talk about what a will does. So what I want you to do, and this is the next place you have a chance to have some fun. But what I want you to do is give me a 1-word definition for a will. So if you were taking notes, you would write will equals and give us a 1-word definition for a will.
Quiet group today.
We
They
did.
should all eat it, to be fair.
That is true. That is true. Okay, if you are taking notes, I want you to write this down. A will equals, and it's a 4-letter word, and the word is note, N-O-T-E. A will is a note. If you were going away for the weekend, you were asking us to watch your home and watch your family, you leave us a note. Here's where we are, here's the phone number, here's the neighbor, here's the doctor's number, et cetera, et cetera. Well, a will is your note, and you're never coming back. So always remember, a will is a note, you're never coming back. So what does a will do? First thing a will does is says who gets your stuff, right? Who are you leaving all of your assets or your material belongings to? Now, remember earlier in the presentation, we talked about beneficiaries. So the other thing we want you to know is when you have things like a retirement plan, a life insurance policy, and you have a named beneficiary, Those monies move by contract, so don't go through your will. If someone made the mistake of saying in their will that they wanted their 401k to go to their brother, but the beneficiary on the 401k was another sibling or a spouse, the beneficiary designation takes precedence by contract. So your retirement plans and your life insurance policies don't go through your will. Will says who gets my stuff. Number two, a will determines who becomes guardian of my dependents. We're going to talk about guardianship very little later in this process, but we know that when your loved one with special needs is a minor, you as a parent or an appointed guardian are their guardian till age 18. At age 18, they become an adult in the eyes of the law, which means they are legally allowed to make their own decisions about where they live, medical decisions, money, who they hang out with, who they spend time with, who they give money to. So if your loved one with special needs may need that added protection of some level of guardianship, the will is going to determine who becomes successor guardian. Now, that's important for a number of reasons. The legal professionals always tell us that if a will does not name a successor guardian, then the determination of that role takes place in court. And we always say, the lawyers tell us, you don't want the person in the robe making that decision. So it's very important to have a will to name a successor guardian if you need one. Now, let me tell you a quick story about what happens all too often in the adult world with people with special needs. Imagine your loved one with special needs as an adult. They are happily living their lives. Either they're working, they're at a day program, etc. Something happens to them where they get sick or hurt. And of course, they're rushed to the hospital. And you as the parent come rushing in to oversee their care as you normally would. Well, with today's HIPAA laws, by law, those medical facilities are not supposed to share that information with you. Now, we hope that never happens, but the reality is it sometimes does. So at the very least, you should consider at least medical power of attorney. So second thing the will does, names who becomes your successor guardian. Third thing the will does is it names the person that you want to carry out your intentions. It's called an executor. You're naming the person to do that. So a will is your note, you're never coming back. Who gets my stuff? Who becomes guardian of my dependents? Who's the executor that's going to carry that out? Next thing we want to talk about is a trust. And today we're going to specifically talk about what a special needs trust is. But we want to stop for a minute and re-grab your attention. I understand that when we talk about trusts, the immediate thought for most people is that's for rich people. You think of things like the Rockefellers and trust fund babies, when the reality is, if you have a family and you have assets, a trust would probably benefit your planning. When you have a loved one with special needs and you want to plan for them after you're no longer here, a trust is imperative, because that's going to hold the assets that you want for your loved one with special needs and to be used specifically for them. So first, let's talk about the trust. Let's talk about what the trust does, and let's talk specifically about why a special needs trust is different. So we said a will, one-word definition was a note. Who wants to take a crack at what a one-word definition for a trust is? If a will equals a note, a trust equals one-word definition. No takers. All right, we want to move along and not keep everybody waiting. So if a will's a note, to complete your estate planning, a trust is a bucket. Always think when somebody ever talks to you about trusts, whether it's a family trust, a special needs trust, a trust is a bucket. What does a bucket do? First thing the bucket does is it holds what you put in it, right? So when we're talking about assets that you want specifically used for your loved one with special needs, when you're no longer here, your special needs trust bucket is going to hold those assets. What is the second thing a bucket does? A bucket, if you think about it, protects what's in it from outside sources. So when we're talking about the assets that you want for your loved one with special needs, what outside sources do we want to protect those assets from? First, the government. When you have a properly drafted special needs trust, regardless of the amount of assets that are in there, and you can have an unlimited amount of assets, the government never gets that money. Number two, you want to protect those monies from unscrupulous people, people that would take advantage of your loved one with special needs. And this is where, when we meet with families, many of them tell us, we don't have millions of dollars. We don't have that amount of money that we need to establish a trust. So we're just going to leave the money that we want used for our loved one with special needs to their sister or their brother. Let's say for this story, our special needs loved one is Paulie. And for this story, Paulie's sister is Patty. So families say to us, we're just going to leave the assets that we want used for Paulie to his sister Patty. There are two problems with that arrangement. Problem number one, it's called the gift of moral obligation, which means it's not legally enforceable. Now, we know you're thinking, because families tell us all the time, not a problem for us, Don. We know that Patty will always do the right thing for her brother Paulie. Here's the second problem. Those assets are now subject to civil litigation. What is the number one civil litigation in the United States? It's divorce. So if you leave assets to Patty and a year later Patty's spouse decides they want a divorce, those assets now become part of that civil litigation, which is what you never intended them for. In the words of my grandfather, it would make you turn over in your grave. So what is the last thing that bucket does? Holds the assets, protects them from outside sources. And last thing that bucket does, you determine how stuff comes out, right? You pour it out a little bit at a time if you thought of it as water, or you could dump it out all at once. Your special needs trust does exactly that. Those assets are designed for your loved one with special needs only. They are the sole beneficiary of those assets. So we talked about a trust. Now what we want to talk about is a special needs trust. Why? A special needs trust is completely different than any other trust you could have. If you are a beneficiary of a trust language says a trust can pay for the health, education, maintenance, and support of the trust beneficiary. A special needs trust cannot have that language in it. Why? Because a special needs trust cannot pay for basic food and shelter. That's what Social Security is designed for. So your trust cannot have that language in it. We emphasize this so greatly for a number of reasons. Number one, this is not the trust you go to your real estate attorney for. It's not the trust you go to your discount legal services at work for. You need a qualified special needs attorney to make sure that trust is done properly. When you work with us, we'll introduce you to them. If you don't have one, we'll refer you to one that's geographically close or, more importantly, appropriate for your situation. If you're finding one on your own, they should be members of professional associations, the National Association of Elder Law Attorneys, or NALA, the Special Needs Alliance, or the Academy of Special Needs Planners, ASNP. The Academy of Special Needs Planners has attorneys that are special needs attorneys by trade and financial professionals like ourselves that have financial expertise in special needs planning. But we emphasize that because we want you to recognize something. When you have a trust, if you've gone through the work, that trust needs to qualify for Social Security. And when is that trust going to get read? It's going to get read after you die, and it's going to get read by a layperson at Social Security, not a qualified attorney. And the layperson at Social Security is trained to look for what are called disqualifiers. Paying for basic food and shelter is one of the most common. Reimbursing family members is another one that's most common. Special needs trust can't do that. So it's very important to recognize that a special needs trust should be in your estate planning if you want to leave assets behind for the sole benefit of your loved one with special needs and still have them qualify for government benefits. So we talked about what a special needs trust can't pay for. What can a special needs trust pay for then? And the legal answer is anything that's legal, as long as it's for the benefit of your loved one with special needs. So if you want your family to be able to change their house, add on a room, adjust their home, special needs trust can pay for that. If you want family members to fly across the country, come take your loved one with special needs on vacation, a special needs trust can pay for that. So remember, a special needs trust can pay for anything that's legal, and more specifically, what you would want to happen and you would want available for your loved one with special needs. That's why the legal side is as equally important as the financial side in that planning.
Can you just confirm, you did have a question at one point,
Okay.
that the money in the special needs trust does not count towards the $2,000?
That is correct. If we did not make that clear, when we talk about ABLE accounts, an individual can only have one, and the maximum amount you can put in it in any 1 year is $17,000. So if you plan on leaving assets beyond that, you need to have estate planning. A special needs trust, number one, your loved one with special needs can be the beneficiary of as many special needs trusts as are out there. Grandma and grandpa can have one. If mom and dad are separated or divorced, they could each have one. Doesn't matter. Number two, doesn't matter how much assets are in there, could be millions. It still does not count against their government support eligibility. That's why it is so unique and why it's so important to have a legal professional do that. Step 9, we talked about this earlier, guardianship. Again, we have a workshop that touches on some of that. We'll happily plan one with Patricia for future reference for you guys. But guardianship is just something you need to consider. We're not saying you should do it. We're not saying you shouldn't do it. Everyone's situation is individual and it's family sensitive. We just want you to be aware that you need to consider financial. You need to consider healthcare, things of that nature. So let's say we've walked through these 9 steps. You recognize that you need to do your planning, or you have some of your planning in place, or equally important, you've thought of in your mind or you've identified who's the person that's going to step into your role. Whether that's a family member, family friend, professional organization, combination of the two. How do we now get that person to provide the level of care the way you do? What do I mean by that? All the things I want you to think about that you do for your loved one with special needs, just because you know it needs to be done. Wouldn't you want somebody who's going to step into your role, know those things? I mentioned Paulie earlier. Paulie's a cousin of mine. Paulie was born with Down syndrome. Paulie's now in his 40s, but Paulie loves heavy metal music. So if we were having somebody take over Paulie's care, wouldn't we want them to know important things like that? This is where what we call the letter of intent comes in. If you've never heard of it, if we talk about our organization being known as Special Needs Funding Coach, then we talk about the letter of intent to be the playbook. If you're asking somebody to step into your role when you're no longer there, if you've said to them or you've done this planning, we financially plan for that, and now here's the best way to care for our loved one with special needs, and you're giving them a playbook. Is it a legal document? No. In conjunction with a trust, it's held up in court, but it's not a specific legal document. There's no format, doesn't get filed anywhere. A letter of intent could simply be a handwritten note if you wanted it to be. A letter of intent for families that are medically involved could be videos to help show people how to care for your loved one. In our organization, our letter of intent is a comprehensive document. It comes from my days from the MetLife Center for Special Needs Planning. They were the first big company to put resources behind special needs planning and develop the document. And it's 38 pages long. Now, we don't tell you that to scare you or intimidate you. We're letting you know that it's there so you don't miss anything. We also promise our families that 80% of what's in that document is in your head. We just want to get it out. What are your thoughts on religion? What are your thoughts on where you want your loved one to live? What are your thoughts on dating? What are your thoughts on work? Which doctors do you go to? Which places would you never go to again? What does your loved one with special needs absolutely love every day? What do they despise and you never want them to see or do? All of those things. And for the families that work with us, we store that document in a digital vault, and every 2 years we remind you that you might need to update it. So let's wrap this up. If you're thinking about this and you see, well, what do I start? Recognize that there's 2 parts to it. The legal part we recognized, and we emphasize the need for a qualified special needs attorney. And the financial side is where we come in. If you have a special needs trust bucket and you're going to put assets in it, what assets are you going to put in it? So I want you to think for a moment. If you went through the exercise of establishing a special needs trust, but you did no further planning on how that trust is going to be funded, then what's going to happen? If you live to your life expectancy, which we hope we all do, then what's going to be left? Your house and maybe what's left in your retirement plans. And while those assets could fund a special needs trust, they're 2 of the least efficient assets to fund a special needs trust with. So what we want to teach our families individually is, how much do you want in your trust? What do you need to have in your trust? And most importantly, what is the most cost and tax efficient way to make sure you're funding that trust and maximizing your resources?
Good question.
Question.
What happens to the remainder of the money in the special needs trust after the person with special needs passes?
Thank you very much for that question. That's an awesome question. The question was, what happens to the assets that are left in the trust when my loved one with special needs passes away? You get to determine it. You get to write it in the trust. It could go to remaining family members. It could go to loving caregivers. It could go to worthy charities. You get to choose, but it never has to go to the government. Excellent question. So how do we help? We call ourselves Special Needs Funding Coach for a reason. If you think about your life in any pursuit that you had a coach, whether it was hobby, whether it was personal skill, whether it was team sports, what does a coach do? Number 1, a coach teaches you the fundamentals. What we do is we teach you the fundamentals of how to maximize your resources and still plan for your loved one with special needs and be able to accomplish other things like retirement, for example. What is the second thing a coach does? They get you better at doing whatever it is that you're being coached on. We want to have you have your best special needs plan possible. And then the last thing a coach does, let's say if it's a team sport or competition, is they want to teach you how to win. And what we want to do is we want to teach you how to win the rules and maze of the special needs laws and financial game. That's what we as Special Needs Funding Coach do. So when we talk about how do we cost efficiently and tax efficiently fund that special needs trust, the best way to fund the special needs trust, the most cost efficient way, the most tax efficient way is life insurance. So what we teach our families are 2 very important things about life insurance. Number one, what current life insurance looks like. Life insurance has today what's called living benefits. What are living benefits? I want you to think about the life insurance you have for a moment. And let's say you have a critical illness. You have a stroke, cancer, heart attack. Now, if you took your current life insurance policy to the insurance company and you said to them, I've not died yet, but I'd like to get some of the death benefit before I die, you know that answer's no. Well, in today's world, life insurance has evolved. Life insurance has developed where it has living benefits. If you have a critical illness, if you have a chronic illness where you need long-term care, you are now allowed to collect against the death benefit tax-free. Eventually, all companies should have this. Right now, there's only a few, and we specialize in teaching our families with loved ones with special needs to have those benefits in their plan. So if any of those things happen, it doesn't explode your plan. We also recognize that parents and family members are sometimes sacrificing their own health to care for their loved one with special needs. So it's critically important to get all the benefits that we can. And then lastly, we want to talk about a specific type of life insurance that's known as survivorship life insurance. It's specifically designed for trust funding. And what it does is it insures two people, but only pays an insurance death benefit when the second of them passes away. Why do we want this type of insurance? Number one, the premium dollar buys a heck of a lot more death benefit than if it was individual. Number two, if we recognize the practicality that as long as mom and dad are around, we're looking out for our loved one with special needs, it's after the second of us passes away that we want that trust funded, and that's a way to maximize your trust funding dollars. So as we wrap up, first, think about the quality professionals that you need to assist you in this planning endeavor on the legal side, the financial side, and all of the other areas of life. Number two, we thank you and we respect the fact that you're the expert when it comes to your loved one with special needs. And when we're talking about planning for their lifetime and long after you're gone, we want you to remember two key concepts. One is a lifetime of care, and the other is the quality of life that you'll provide. So as we get ready to wrap up, number one, thanks for sharing the hour with us. Number two, please respond to that survey. Number one, if you've attended this workshop, we will provide a 20-minute consultation to answer any of your individual questions. Number two, if you provide us your address, we're going to send you that folder we mentioned. And in that folder has some key documents, a one-page special needs planning quiz, a quick list of yes or no questions to get your thinking started, a brochure that describes the overview of what special needs planning is, kind of the legal and financial side we talked about today. And last one is a real important one, which is the most common mistakes families make that we want you to avoid. So, Patricia, thanks again for hosting us. Anybody have questions? We'll stay as long as you like. And please, please, please respond to our survey. Our contact information is on the screen. Don't forget our website. And please, we'll be happy to work with you in the near future if you'd like.
Once again, thank you very much, Donald, for taking the time and educating us about this important topic that we know a lot of family can benefit from this information. Elizabeth, thank you as well, because I know it was a lot of back and forth in order to get this presentation done today. So thank you very much. I also want to remind everybody, if you know any family or any person that needs this information, please keep in mind that the presentation was recorded and they can have access to that information in the YouTube channel, Family Partners of Morris Sussex County. In the description box below of the video is going to be contact information, email, and everything. All of that is going to be there. So once again, thank you very much. And with that, we're going to go to our Q&A session. That part is not recorded.